Welcome, everyone. Thank you for joining us. My name is Jamie Schenker-Passero. I am the Associate Director of Temple Small Business Development Center. If you are new to us, we help small businesses start and grow. Lately, we help them with crisis management. So we are offering webinars on various important topics. We have our consultants who are able to talk to you one-on-one. These are all no-cost services since we are funded by the Small Business Administration. We are also offering virtual Zoom office hours every day from 3 to 5. I'll put a link in the chat box. That's a good way to connect with a consultant if you just have a few questions. I'll also link to our resource page. We're updating that every day. It's a Google document with helpful links, resources, our upcoming webinars, as well as recordings of previous webinars that we've done. Today, you're joining us for a chat about how COVID-19 may be impacting your contracts. And we are lucky to have Tony Lopes of Lopes Law LLC and host of Self-Made Strategies podcast today, who will be talking to us about that. Everyone is muted. If you have questions, you can put them in the chat and we should be able to get to them. So thanks again, Tony.
Hey everyone, yeah, thanks Jamie for that wonderful introduction. And if I break up, because we're working remotely, so we have to deal with technical challenges, of course. Hopefully Jamie can just kind of signal me. I have the chat up, or let me know if I break up. I will try to repeat myself as best as possible. Sure. So, all right, I will share the presentation and we will get started. Of course, I'll be happy to take your questions towards the end. And hopefully this will be an informative presentation for everyone with what we're facing, providing some knowledge and some support regarding how to deal with contracts during this very uncertain time for us. So a little bit about me. First and foremost, I am nowhere near as funny as Jamie. So if you're used to dealing with Jamie, I apologize in advance for my terrible jokes. And I'm working on it. I'm working on the side hustle of being funnier. I also own and operate and founded my own law practice where we do a lot of contracts, negotiations, tax law, estate planning, intellectual property, mergers and acquisitions, franchise law a little bit, employment law, and nonprofit law. Basically, the best way to think about it is it's everything that an entrepreneur might need. Fair warning, you may hear my dogs in the background. Hopefully not, but it's one of the things we have to deal with in April of 2020. So hopefully they'll be quiet for this presentation. So I'm also the founder and host of the Self-Made Strategies podcast. As Jamie said, Jamie was gracious enough to be one of our guests where we talked a lot about the Temple SBDC and Jamie's own business. You can catch the podcast on iHeartRadio, Apple, Google, basically everywhere you can find podcasts.
I'll link it in the chat also.
Great, thanks, Jamie. And I'm also an adjunct professor at Temple University at the Fox School of Business. I teach technology, privacy, and intellectual property law, legal environment and business, and entertainment law in the fall of 2020. Just a quick disclaimer, I'm an attorney, so I'm rich in disclaimer language. This webinar is not providing you with legal advice. Obviously, if you need legal advice, please reach out either to me or to another attorney, and we'd be happy to help you. But your particular and individual situation is always very unique to you. So if you need help or want to chat, just make sure you reach out. You can contact us at info@lopeslawllc.com, or you can call my cell phone, my work cell phone, 267-777-9117. You can also send a text message, smoke signal, etc. That was a joke. So what we're here to talk about today at a high level is how to deal with your contracts primarily, and some other situations that are tangential to your contractual relationships with all of your stakeholders. When we say stakeholders, we mean your clients, your vendors, your community at large. Stakeholders kind of includes competition, not so much in this context, obviously, but in general, we just mean everyone that you might have a contractual relationship with. So what we're really looking at a high level is solutions to prevent breaching those agreements, right? So we're all in this together. It's a little bit of a mess right now, and we all understand that, but Open communication and transparency, which is something that we'll talk about, how to negotiate, how to communicate with your stakeholders, is really important right now. And then we're going to look at also at a high level, what happens if the supply chain breaks down or slows down? What do you need to be doing? What do you need to be adding into your agreements to make sure that you're protecting yourself? In addition, we'll look at how to protect all of those valuable relationships that you've spent so much time cultivating and building up. And then we're going to look at a high level throughout the discussion, both practical versus theoretical approaches, because there are certainly theoretical approaches. What does the law mean at large? What are contractual provisions and how are they enforceable? But then there's a practical day-to-day application of those provisions, and we'll discuss that as we go. We'll also take a look at negotiations, communications, and transparency, which I think are keys to success in any relationship, especially contractual, and how, at a low level, how emotional intelligence and awareness can really help with those discussions when you're having them with stakeholders. Also, we'll talk about strategic collaboration as a solution to building stronger relationships with your stakeholders. So hopefully turning a lot of the negatives that we're facing into positives. We'll look at master service agreements at a high level. We'll talk about amendments versus modifications versus just drafting new agreements and why it depends more specifically to your situation. Then we'll look at force majeure clauses. I promise that'll be the only Latin in this presentation. And we'll try to focus on, again, the practical application of those things. If you Google or do any of your own research, again, I try to be as practical as I can be when working with entrepreneurs. If you're doing a lot of your own research on the back end about this stuff, you're going to find a lot of these clauses online. I'll say that you want to exercise a lot of caution when you're reading these, because a lot of times they're one-sided, they're very filled with legalese, which no one really understands. And I am of the opinion that the more clarity, the better. And I know that, we want to cover ourselves and we want to protect ourselves, but when it comes to force majeure clauses, as we'll see later in the presentation, these are opportunities to collaborate and not really loopholes. And we'll talk about the differences. Throughout the presentation, we'll talk a lot about just thinking ahead and being strategic about all of this, right? So what happens after we eventually get released back from quarantine? I know in the news recently, the PA House has passed some legislation about potentially bringing some more businesses out of the quarantine or out of the stay-at-home order, and we'll look at that at a high level. We won't go too deep into that, but I do want you to think about that when you're having discussions with your attorney and any other professionals that you're working with. We'll also take a look at the ABA Model Standstill Agreement, which was recently drafted and prepared by a Temple Law professor. And we'll talk about that agreement, the good and the bad side of both of those things. And then lastly, we'll look at the PA amendment to the unemployment compensation law. Again, at a high level, I just want you to know these things in case you have employees who you're thinking about laying off or who you have laid off. And we'll also look just slightly at subcontractor agreements and where some danger might lie in there as well. All right, so let's start with master service agreements. What's an MSA at a high level? Basically, it's a template that you might use for all of your products and services for others. So if you're a vendor, if you're a venue that does events, I know the wedding industry is facing a lot of issues, as well as some other industries are facing similar issues, restaurants, of course. So if you have events that were previously booked, you may have used a master service agreement that you've always used in the past, but that agreement is, of course, legally binding like any other agreement, presuming that it's signed, that there's consideration, all of these things. But what we want to look at is maybe now is the time to take a look at those agreements and update them for the future, make them more inclusive of issues like this. We also might want to take a look at those agreements to make sure that they were well drafted to begin with. Not being critical, but I have seen many, many, many poorly drafted master service agreements. A lot of times entrepreneurs may even just grab them from somebody else or may have found a template online, and you think you're using it and you're protected, and it may be opening you up to a lot of liability risk. So if you have an existing master service agreement, hopefully it includes the provisions that'll allow for modifications to begin with, and we'll talk about that a little bit more later. But also, we need to look at what the opportunities are to continue that relationship, to maybe postpone or reschedule some of the events that you have if you're in that space. And we'll talk about some of those issues. If it doesn't have provisions allowing for modifications and it doesn't have, for example, a force majeure clause, then maybe it's time to do some damage control. And so you might want to ask your current stakeholders, again, clients, vendors, all of those relationships that you might have been using master service agreements with, to consider signing an updated version. I'm sure they're going through a similar situation as you. We're all in this together. So you might be able to get an opportunity to renegotiate that, not at any crazy level, but in a way that's mutually protective of both parties, offers you some outs. But one of the considerations, and we'll talk about this when we get to the negotiations portion of the presentation, is how can we offer some added value to incentivize people to be more accepting of these updated agreements. So breaching your agreements in general is basically where you violate your agreement that you have with another individual or another party for either non-performance, interference with another party's ability to perform other agreements on their end. So maybe you are a vendor or you are a intermediary of some sort, and you have an agreement where if you're a caterer, for example, well, you might have an agreement with a hall or another wedding venue, just as an example, and you may not be able to deliver on your promises, and therefore they can't deliver to their clients or the weddings that they're supposed to fulfill. Obviously, there are no weddings going on right now, but once we get released from quarantine, we're under this uncertainty of what's going to happen then. And this is one of those situations where we need to look for solutions that also not only cover the right now, but also look to different periods of time in the future and how we can balance those things as we go. So a lot of times when you breach an agreement, the remedies for the other party are recovery of financial harm, which is the last thing anyone needs right now, damages, which is kind of part of that, but more inclusive, specific performance, meaning requiring you to perform the agreement, or cancellation and restitution, meaning, maybe you had a deposit from a client to hold a certain agreement in place. Well, if you're in breach of that agreement, they may be able to cancel the agreement and require that you pay them back their funds. No one gets scared here. We're going to talk about these things and talk through solutions, but these are considerations that we have to have at least in the back of our mind when we're looking at the potential risks that we're facing. Another concept that we'll talk about, and this is more towards the ABA model agreement that we'll talk about closer to the end of this presentation, is this concept of tolling. And what tolling means is basically that it'll push the statute of limitations back to a later time, or it'll extend it. Sometimes this can be done by agreement, and sometimes it can be done by action. And what I mean by doing it by action is this example that I have here on this slide, where let's say you fall behind on payments to a vendor because you lack the liquidity or the cash flow right now to keep up all of the necessary obligations that you have. Well, let's say you say to them, okay, I'm a couple months behind, or I'm a month behind, I'll do a partial payment. Well, that now may restart the statute of limitations on their ability to sue you at a later time. In Pennsylvania, generally speaking, the statute of limitations on contracts is 4 years, but sometimes 6-year statute of limitations apply to causes of action for, say, unfair trade practices or consumer protection laws. Presumably, grain of salt, we're not in that longer 6-year period here on what we're discussing. Breach of contract would fall under the 4-year statute of limitations. But nonetheless, that means that things that are happening to us now could stretch out as far as 4 years and cause us problems. And one of the key mantras of my law firm, if you will, is that I frequently tell clients that we strive to keep them out of court. I know a lawyer that doesn't like litigation, right? But the concept is, if we draft agreements right, if we have open communication and transparency early enough on, hopefully we can avoid some of those issues at a later time. So what about amendments versus modifications versus drafting a new agreement to begin with? Well, quite frankly, it really depends. So we'd have to look at your pre-existing agreements, those agreements that have been executed, that are enforceable between you and the other party. And we have to look at that agreement to make sure that there are provisions in there that A, allow for a modification or an amendment, and that lay out the terms for that, right? So the modification provision in your agreement may state that any modification can be made to this agreement as long as it's in writing and executed by the parties. Or it may say something else. It may have some requirement for some notice provisions. And that just means essentially that there may be a time period that you have to send something in writing. And then that kind of has implications with respect to the rest of the agreement, right? Then we'd have to look at the notice provisions within the agreement and see what the requirements are there. Do you have to send it certified mail, which might be a little bit tougher right now for business owners to do, or can you just send an email, for example? And either way, we need to look at those provisions to see, can we do things that modify this agreement, or do we need to start from scratch with a new agreement? And if so, what are the terms for termination? There are a lot of implications that go into all of this, but the best thing that we can do is look at it holistically and say, okay, we reviewed the agreement, we take a look at what the provisions are, here are what our options are, and then figure out what's the best case scenario for the parties involved and how we can find ways to be more collaborative and come to terms that are more beneficial to both parties to either redraft a new agreement or to modify the existing agreement, etc. So if we're doing new agreements, if we're drafting new agreements, it really depends, again, a lot on your current agreements and whether or not it makes more sense to draft a new one, as we said, or if it's best to renegotiate everything, terminate the prior agreement. Then we need to look at the termination provisions. There are creative ways to get around these things, but the more flexible your prior agreement is, the better off we'll be at the end of the day. So force majeure clauses. For me, I'm currently working on a merger and acquisition deal for a client. Obviously, I won't divulge any of the client's details, but we were in the middle of a merger and acquisition when this all happened. So just as a backstory, my client's the buyer in the situation, was buying a pre-existing business. And obviously now the seller wants nothing more than to sell the business. And we were in a situation where we had finally come to terms and we were right there about to execute the agreement. Luckily, we did have modification provisions built into this agreement. We did have a lot of other alternative provisions, but luckily we had not executed the agreement yet. So we were able to just revise the agreement, add in a force majeure clause. But part of that now in the middle of the deal is we don't want the deal to fall apart, right? That could also be the worst case scenario, not only for my client who does want to buy this business at some point, but also for the selling party. And we don't want the deal or the relationship to deteriorate necessarily, because the parties do still want to go forward with the transaction. So what we did was we drafted a custom force majeure clause that includes provisions that allow for flexibility with COVID-19 specifically, but also governmental shutdowns like the stay-at-home order, et cetera, and that offer additional provisions because, again, we're not exactly sure. There's a lot of uncertainty about where we will be in roughly 3 months, 6 months, 9 months, 12 months. So a lot of this is we're all in this uncertain period. So how do we deal with that uncertainty in an effective way and provide solutions that, again, yes, protect my client first and foremost, but also at the same time are sensitive to the seller's issues, right? Because again, we don't want the deal to fall apart necessarily. And in order to see that M&A deal all the way through to the finish line, we need to incentivize the other party to be willing to accept this force majeure clause without causing a lot of other issues. So we added in some contingencies that the buyer will only be required to close if they are actually allowed to operate the business. And then again, this force majeure clause. So force majeure clause, stepping back a little bit, is essentially a act of God clause kind of situation. You may have seen this a lot in insurance agreements. You may see it in other places as well. We're going to start to see it in almost every agreement, most likely. And essentially it lays out all of this, all of these parade of horribles, if you will, of situations that are outside of the control of the parties, right? So it's not really a loophole, but it's a situation where, hey, if something happens that's outside of both of our control and I'm at no fault, that is a key issue here, right? Which with respect to COVID-19 and with respect to governmental shutdowns, presumably none of the parties are at fault. So it's a clause that protects these parties for those situations and allows outs, either termination of the agreement, extension or staying or tolling, whatever verbiage you want to use, but essentially allowing for more time to finalize the deal and to come to terms on the agreement or to fulfill the requirements of the agreement. So a major issue with force majeure clauses, though, is that they really only protect the events described, especially if you start to get fairly specific with the types of events that are in it. So some force majeure clauses may not protect pandemics. Pandemics may not be a force majeure event. Governmental shutdowns may not be considered a force majeure event. It depends what's in the clause. And again, going sort of back to what we talked about before, there are situations where we hopefully can modify the agreement with a simple amendment or a simple modification attached to the agreement and executed by both of the parties, saying that we're modifying the force majeure clause or we're adding a force majeure clause to the agreement so that the parties can see this thing through to the end. Generally speaking, what I would suggest you want in these situations is something that's inclusive, that covers now pandemics, epidemics. COVID-19 can be listed as an example. Governmental responses to pandemics and epidemics, governmental shutdowns or quarantines. We list all of these things out and we try to be as inclusive as possible, but in the clause that we drafted, which I did not see a lot of examples of in general, the clause allows for outs for both parties. And it allows for different time periods to check back in and open up the lines of communication with respect to these events to say, okay, here's where we were when we signed the agreement or when we modified it to add in this force majeure provision, and here's where we are now. And do we want to continue forward? Do we want to re-extend that provision? So it allows for time periods, but also with some outs where either party can say, look, this is not going to work for us. We can't fulfill this contract. You can't fulfill this contract. So maybe we should just terminate it. Maybe that's the case, maybe not. This is one of those situations where it really is very specific to the meeting of the minds, if you will, of the parties. We want to cover as many unforeseeable events or circumstances, but there's only so much that we can do. And there's also only so much that we can plan for, but the concept is we can allow some outs in there for some flexibility if we need it. Okay, so what if you don't have a force majeure clause in your agreement? Well, we should start adding them right away. We should add them now, looking ahead at any future agreements that we execute with stakeholders, but we should also consider this because this needs to be a long-term strategy, right? As we know, we're in quarantine right now or under the subject to the stay-at-home order, and we don't really know with any real certainty when that will end. But again, looking at the new normal, whatever that is, when we come out of this, look like it, and we just don't know. We just don't have enough certainty. So in my perspective, we should be adding these things in. We should be considering the implications of this both now, but then also, what if this PA House legislation passes and now new businesses are allowed to reopen? Well, you might be in a situation then where your stakeholders say, well, now you're allowed to reopen, so I need you to fulfill what our original agreement was. Is that really practicable? Do we know if that's an actual practical solution in real world scenario? We don't. Even if the government allows for businesses to go back or says that they're going to expand the definition of businesses that are allowed to operate, what position does that put us in? And do we still want to have some flexibility to say to our stakeholders, we understand that we're allowed to go back to business, but we want to protect our workers and we don't have enough PPE? Or, you know, what if you have a COVID spread within your organization? We've seen obviously in the news that, and by the way, I'm generally a much more positive person than this, but we've seen in the news that generally speaking, if you have a COVID outbreak, for example, if you own a factory or you own a restaurant, what effect will that have on your business? And then what effect will that, in terms of a domino effect, have on these contractual relationships that you have with your stakeholders? So we need to look at those situations. We have to have a heart-to-heart discussion, for lack of a better term, about what the realistic application of these things in the real world is. You can, I don't believe in this, but a lot of people draft contracts without thinking through the entirety of the situation and all of these non-black and white issues that pop up, right? Things that we may put in the agreement, if they're overly broad, again, just like we pointed out in force majeure clauses, may not cover our actual practical real world situation. So we need to think about these things at a high level and try to figure out what the best way to approach them is, draft strategically around that, involve all of the parties so that they're coming to the negotiation table to have some input and to have some ability to say, you know, this is what we're looking for, this is what we need, and then discuss those things realistically to see if that's a realistically plausible outcome. So again, I think that open communication is really the best approach in a lot of these situations. We need to be strategic in our open communication. Of course, we don't want to scare off our vendors or stakeholders or clients, but a more open approach is probably going to be much better accepted than them having to come to you and saying, hey, these agreements aren't being seen through, what's going on here, right? And again, we want to look for a common ground. We want to draft something that's inclusive of their situation as well as ours, so that we can protect all parties involved reasonably and protect the relationship, because I think that's really, really, really going to be important coming out of this, that we need to build relationship capital so that we can protect our business going forward. So looking at the ABA model standstill agreement, and I don't know if Jamie already linked to it, but I'm sure she'll be able to email it out.
Yep, I'll add that in.
Sorry, I broke up there, right?
No, you're good, but I'll add the link.
Oh, okay, thanks, Jamie. So the ABA model standstill agreement, model standstill agreement, sorry, on the whole, first and foremost, I'm gonna go down to the bottom bullet point and then we'll go back up to the top and come back down. So I wanna be very clear that while it's helpful, and I appreciate the position of those who drafted it in trying to provide a solution that can be put into play now for entrepreneurs, especially while we're struggling financially and while we're trying to figure out our cash flow and all of those things, and we don't want to be spending unnecessary funds on legal fees. It is a model agreement. It's essentially a template. And I say that with no offense whatsoever. I say that more so in the context that while it's helpful as a guide, you have to be very, very careful, because it's very broad. It's all encompassing. It's meant to apply to as many situations as it can. It's a model agreement. It's a model. So speaking with an attorney, having a consultation with an attorney, whether it's myself or another attorney, is critically important. And you want to make sure that your attorney or any of the professionals that you're working with are saying the things that match what exists in your world on a real day and real basis, right? Because you can have anything in an agreement, and we'll talk about this a little bit more when we get to subcontractor agreements in a second. You can write anything into an agreement that you think you're agreeing to. Whether or not that's actually enforceable at a later time is a completely different story. So if it doesn't match your real world relationship, that agreement might not be that valuable. Again, I'm not speaking just about the model agreement in this context. I'm saying agreements in general. Subcontractor agreements are infamously bad at this, because a lot of times people will just use a subcontractor agreement, again, that they got from somebody else, or that they've been using as sort of a master subcontractor agreement. that wasn't drafted for their specific business or something along those lines. And it can get you into trouble because you're signing something that's going to be legally binding on some level, but may not match your present situation. So I do encourage some discussion with an attorney so that you can be properly advised on what needs to be in there and what should be removed or modified so that you can get an enforceable agreement that matches what's happening to you in the real world. Okay, so again, going back to the beginning of this, it's a great starting point. I think it's very helpful as a guide, but preferably, I cannot emphasize enough that in this case, you should definitely consult with an attorney. And it's specific to COVID-19. There are a lot of COVID-19 references and provisions which can be helpful. But again, be careful because the agreement itself may have issues with what's called consideration. I'm going to stop the presentation for a second because I'm just going to glance at the agreement on my second screen, because this agreement, while otherwise well drafted, this is my opinion, as my academic opinion, if you will, as an attorney, its consideration statement says that in consideration of the mutual promises set forth herein and other good and valuable consideration, the receipt and sufficiency of which are hereby acknowledged, the parties hereto intending to be bound agree as follows. That is a classic provision you see in a lot of agreements. The problem, from my perspective, and there are others who academically agree on this level, is that just because you're saying that there's consideration doesn't mean that consideration actually exists. So talking about consideration, I'll try to keep this as palatable as possible, but consideration is a concept that creates a valid and enforceable agreement. And basically, it's the quid pro quo. See, I lied about how much Latin there was going to be in this presentation. It's the exchange, the promises, if you will, or the cash in exchange for a service, or the cash in exchange for a product, for example, between the parties that makes a valid and enforceable agreement. With respect to this agreement, the problem is that there's no new consideration. So if this agreement stands to modify a pre-existing agreement or stands to replace that agreement, while in the preamble it talks about how the disruptions of COVID-19 are the reason that you're creating this agreement, and there may be some merit to that, there may even be a solid argument for that being sufficient consideration, I'm not comfortable with that with respect, personally, with respect to its enforceability at a later time. So what my whole point with all of this is, you should be consulting with an attorney about whether or not there's enough here to make this new agreement valid and enforceable, because the last thing you want is that you take this model agreement, you execute it with your stakeholders, and you say, okay, we're good, we're covered. We've covered ourselves with respect to COVID-19 or any outcomes. And then, as we said, the statute of limitations is 4 years. And later you find out you get sued by somebody, and you say, whoa, wait a minute, we signed this model standstill agreement. We were all in agreement. We were all happy about signing this agreement to extend. And that's when it gets ugly. And you don't want to find out at a later time that when it comes to court, you've got to pay an attorney and essentially waste money on legal fees to go and try and enforce this agreement in court. You never want a court, if possible, deciding the outcome of your agreement, right? I wouldn't want that to happen. So again, our objective here is, how do we strategically find ways to modify our pre-existing agreements so that if it's part of the agreement, there's a better chance that we can enforce it, or that we can go and very quickly and easily say, no, 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 you signed this modification, and clearly we added this force majeure clause, et cetera. With this new agreement, you'd have what lawyers might call battle of the forms or something along those lines, where you're trying to argue that this agreement's enforceable and your stakeholder is trying to argue that the prior agreement is enforceable and you were in breach of that one. And again, you don't want this terrible situation determining the outcome. And let's face it, litigation is very costly. So our objective here is to avoid that. That all being said, and I apologize for the verbose explanation, but that all being said, it's a good start. It's a good place to use as a guide, as a model for drafting a new agreement if you need one. But again, it's very specific to your situation. I would want to see things in writing that are very detailed about, you know, that there's some actual consideration there, what the new consideration is. And again, a forgiving of promises. There are settlement agreements and releases and those types of agreements. So a forgiveness of the requirement to perform under a contract could be consideration, certainly. But again, speaking to an attorney and working through this whole situation to make sure that you're protected is really important. Again, that said, this could be a very valuable agreement, or at least starting place for you. And I personally do love the proactive nature of it, that's trying to provide solutions for entrepreneurs who might need the help. Okay, let me bring the presentation back up. Sorry about that. So looking just really quickly, and we won't go too heavily into this, but recently there was an amendment to the UC law, to the unemployment compensation law. So for those of you who have employees who are listening to this presentation, just want you to know that there have been some modifications, that the law is changing on a day-to-day basis. So that might be a good reason to reach out to your professionals, to your attorneys, to reach out to us if you're concerned about something that's going on. And the modification basically states that all employers that are required to abide by this specific UC unemployment compensation law must provide notice related to the availability of unemployment compensation to an employee at the time of their separation. It doesn't really define separation in this amendment, but most likely it's referring to any form of termination, layoff, a temporary layoff, a furlough, or even a reduction in hours. It could apply to those situations. So again, just want you to be careful that the law is ever changing. There are things happening on a daily basis. I don't want you to be too anxious, but communication is key, not only with your other stakeholders, but with the professionals that you're working with. There are also some potential issues with OSHA now, because you may have some occupational safety concerns with providing your employees with PPE if you're requiring for them to come to work. So there are a lot of these moving tectonic plates in the legislative world that are now affecting how businesses are being run on a day-to-day basis. And we need to have those considerations when we're thinking about them. So speaking of agreements that may not apply, subcontractor agreements are infamous for this. So again, people frequently draft and execute subcontractor agreements and think, I'm good because I have a subcontractor agreement. The agreement says that this individual is a subcontractor and is not an employee, but I will tell you that the nature of the relationship in the real world is what generally applies to whether or not they're going to be treated as a subcontractor or as an employee. So generally speaking, when we're drafting subcontractor agreements, we're trying to think as much as we possibly can about the federal requirements, which list out factors that balance the difference between an employee and a subcontractor. And yes, the agreement's important, but you want to look at the agreement also as a guide and a checklist, so to speak, for lack of a better term, of how your relationship should be in the real world. In my general interpretation, if we're looking at this from a 30,000-foot view, it's generally speaking about who's in control. So if you, as the employer or prime that's hiring the subcontractor, is in a lot of control, you control their hours, you control the equipment, you control when and where they show up for work, you control how they deliver the work, you control non-competes, some of those other issues. You could have more of an employer-employee style relationship than an actual subcontractor relationship. And why is this important right now? Well, quite frankly, again, just with the provisions that we covered with regard to unemployment compensation, that matters. That difference matters significantly about where we are. So this is also an opportunity to take a look at your subcontractor agreements. And it might also be a good opportunity to have those contracts not only reviewed by an attorney to avoid surprises later, but also to cover wrongful acts or omissions by your subcontractors, which could theoretically affect these outcomes or your requirements to deliver with respect to your stakeholders, to your clients. Also, you may want to have some force majeure clauses built into the subcontractor agreement that offer you and the subcontractor some outs and some flexibility if things aren't working out right now and you need to either take a break from the subcontractor relationship or even let them know that you don't have the work right now to fulfill that agreement. So some of those clauses and provisions encompassing some of these concepts might be useful in those relationships as well. All right, so let's talk about negotiation, about collaboration, about open communication and transparency. One of the big things in my view is communication is king, and having a collaborative approach always leads to better outcomes. I say that with a grain of salt, of course, but generally, let's say, leads to better outcomes than being in a situation where we are trying to get as much as we can for ourselves and not thinking about the other party. Where is this relevant right now? Well, quite frankly, if you're going in to try to renegotiate a lot of these agreements, or if you're going in to try to get to your stakeholders to have them agree to modifications to the agreement, we need to also be emotionally intelligent about what's going on in their world. Right now, we tend to really be hyper-focused on everything that's happening in our world because there's so much uncertainty and because we're just trying to keep the ship afloat, for lack of a better term, and rowing in the same direction. But if we're more considerate of what's going on with our contractual stakeholders and those individuals that we have obligations to, or stakeholders at large within our community, people are going to they're going to remember that, right? It's all about how you make them feel. I know we're getting off the topic of legal advice here a little bit, but from a negotiation strategy perspective, negotiations are not about you or me winning. It's about us coming to a collaborative meeting of the minds, so to speak, to get to the goal, to get across the finish line together, whatever that outcome is. And so think also, put yourself in the other party's shoes and think to yourself, if I wouldn't accept this deal or this modification, why would they? And that's where we start our negotiation strategy from. And of course, as an attorney, I seek to protect my clients mainly, of course, but part of that protection is not allowing the deal to die or advising them, playing devil's advocate and getting them to think about these concepts and saying, let's take a step back, let's take a deep breath and think about this. Would you take this deal? Do you really think they're going to accept this deal? And then what are the strategies that we can use to make sure that we're maintaining these relationships? And generally speaking, my approach at least is, I heard someone once say at a presentation, and I wish I could remember who the individual was, but he was a CEO of a major corporation, and that was at the United States National Convention for the U.S. Hispanic Chamber of Commerce. And I remember him saying that your focus should never be on ROI, return on investment. It should be on ROR, return on relationship. And largely that's because we're building this long-term game plan, right? We want to maintain these relationships that we've worked so hard to build. So we need to take a step back, take a deep breath and say, let me not focus on this one transaction that might kill the relationship later on down the line. Let me look at the big picture. And I'm not saying that the transactions aren't important, but looking at the big picture is a good perspective, generally speaking, when it comes to negotiation or finding a collaborative point of interest to have some open discussion. Again, open communication is really important, and we need to be transparent strategically with those stakeholders that we're working with. So you're concerned about the future, no question, but so are they, right? They're all also worried about their families, their businesses, what this all means. They have needs and concerns of their own as well. And we don't want to be emotionally reactive. We want to be really strategic about how we approach this. and be emotionally intelligent about how we approach these discussions so that people will be more willing to work with us. So this is a great opportunity to really fortify those relationships through open communication, proactivity, and collaboration. And remember, it's about how you make them feel. So if you're making it about adding value for them, they're not only going to want to agree to being a part of this modification or this bigger strategic plan for both parties involved or several parties involved in a transaction, but they're also going to remember how you made them feel a year down the line, 2 years down the line. And that builds a lot of brand loyalty, a lot of brand equity, and equity in the relationship. So providing notice strategically and getting things in writing, so that there's some record, again, strategically. And why I say it's a two-sided coin is because we don't want to put anything in writing that could later cause us some liability, right? So I recommend no knee-jerk reactions, really being strategic, really taking our time and discussing things with lawyers and other professionals that you rely on for advice so that you can come up with a strategic plan and initiative to get through this together. Okay, that was the presentation, and I'll take questions now. Thank you guys all so much for your time. Don't forget to follow Self-Made Strategies and Lopes Law LLC on Instagram. And you can always contact us at info@lopeslawllc.com or call or text us at 267-777-9117. Thanks.
Thank you so much, Tony. Do we have any questions from the attendees? If so, you can type them in the chat. Give it another minute. Okay, well, then I'm going
I think I put them all to sleep.
Oh, there may be a question.
Oh, Diane
yeah.
may have something.
Okay. All right. I have a question in the Q&A about phone contracts.
Can you elaborate, whoever asked
Yeah,
the
I'm not
question?
sure. So the person who asked that, maybe you can either post in the Q&A what specifically is the question. And then while we're getting more clarification, another question is, please give some examples of valid and sufficient consideration for modification agreements.
So if we're talking about a modification of a pre-existing agreement, and we're talking about something where the agreement itself allows for modification of the terms of said agreement in writing and execution, we should be okay. And from a consideration perspective, we would just be adding some amendment to that pre-existing agreement. Amendment, modification, those are all just really semantic terms, which is what I had on the slide there. It's basically the same thing. Some nuances there, but essentially, as long as we're allowed to from the pre-existing agreement, we can simply draft a modification. It might even be one page. It depends on how many things need to be modified in said agreement, but we can modify that agreement just with an executed document that then will get attached to that, right? Now, if we're talking about something like the model agreement, or if we're talking about something where we're drafting a new agreement, we may need some new consideration. My whole point with the consideration rant, for lack of a better term, is that we need to focus on ensuring that we have consideration, right? So maybe it's a forgiveness of promises, maybe it's a restructuring of the deal, maybe it's an understanding that we are going to continue this relationship, which is similar, again, to what's in the model agreement. I just want you to be really careful about not taking a template, adding some parties and executing it and thinking that you're okay. You're not, unless you talk to an attorney and make sure that this really fits your situation. Does that make sense? Did I answer that question effectively?
So you're saying, in general, the consideration from the original contract is probably sufficient when you're doing a modification?
Generally speaking, you can restate it and just say, hey, we're terminating the prior agreement and here's the consideration going forward. But I don't think it's enough to draft a completely new agreement and just say, hey, for consideration that we both agree is here, we're good. Because you're still significantly, in my view, exposed to potential liability at a later time. So due care is really what I'm focusing on there. And it depends on the specific situation.
Okay. So this,
so John's question about the phone agreements, I'm assuming you mean either cell phone agreements or work lines or something along those lines.
Yeah.
I would suggest reaching out to the carrier and hopefully coming up with some modification or extension, or where, you know, you're not necessarily going to be breaching that agreement and putting yourself at risk from a credit perspective or anything like that, but come up with some way to get past that and just say, hey, look, you know, we're not going to be able to cover 5 lines because we're not operating right now. Would you be willing to give us some sort of forgiveness period, or let's say like 3 months off, where you can temporarily shut down the phones, shut down some of the phones. You may not want to shut them all down. So maybe coming up with a strategic term. With a carrier, it's going to be, you know, a lot of those agreements are boilerplate, lengthy agreements. I think this discussion applies more to open communicative relationships between parties that are interacting on a more frequent basis. But my suggestion generally would be call the carrier and say, hey, look, we're not operating right now. We're not getting any revenue coming in the door. We need to take a break from this. What are our options? And hopefully, you know, fingers crossed, the carrier will permit you to do some kind of forbearance or just taking a break from your cell phone agreements or your phone agreements and give you an extension where, you know, 3 months or 6 months down the line, once you're rolling again, maybe they're going to re-up that agreement. I don't know.
I think this makes sense. It's more of like a customer relations thing, really, is that when you have these bigger companies, they do want to maintain their customers. They do want to show some good faith here. So I think that's more of kind of like thinking about your negotiation position as a customer and making sure that the company that's providing you a service is working with you and just being human. We got to be human right now. Question.
Yeah, exactly.
So question,
Let's see, Diane.
Yes, this business has an event space. People are asking for the money back. But I'm sure this is coming up a ton. The contract says no refunds. But I did say they can use it within a year's time. So somebody books an event, the contract says no refunds, and this business is saying, okay, well, we can't do a refund, but we can offer you the same space again within a year. Some people are okay with that and some are not.
So I'm going to echo Jamie's advice here, which I think is sound advice. We live in a world where especially someone who owns an event space is probably subject to reviews and a lot of other issues, right, that go into this. And this is where that discussion about the practical versus the theoretical applies, right? The theoretical is, yes, you have an agreement that says no refunds, and theoretically you could enforce that. But from a humanistic perspective and from a goodwill perspective, being strategic, as you said, some people are willing to reschedule and pick a later date and stick to it. So you're not going to lose all of those. The ones who want to walk away, you kind of have to make your own decision, Diane, about how you want to deal with those scenarios just from a relationship standpoint. My advice, just at a high level, and again, this isn't direct legal advice, but generally speaking, might be to just reach out to them and say, look, we understand you're going through a hard time. We're all going through hard times. Where can we meet in the middle here somewhere? Maybe you give them a partial refund. Maybe you do something along those lines. My focus personally, this is just me personally, would be to maintain the goodwill and hopefully they'll come back. But it's a very tough and difficult situation to face. Diane's also asking about non-essential commercial space tenant who hasn't paid the rent nor partial as he suggested. what should you do? Very specific question, Diane. A little tough to answer just based on that information, but generally speaking, again, it kind of goes back to the same concept. I don't think at a high level, and this is just speaking generally, I don't think you're going to be able to evict them. So right now, currently, so a good idea might be to approach them and saying, hey, you're really behind on your rent. I am trying to work with you. Again, taking that collaborative, value-added, them-focused approach and saying, I'm really trying to work with you. I want to help you. But if you're not communicating with me, right, it's the flip side, and you're not paying your rent at the same time, you're kind of handcuffing me here. So do you want to come to terms where you pay a partial rent? And then I've seen some individuals adding an amendment to their lease agreements that says, okay, you owe X amount for the last 3 months, you're behind. So here's what we're going to do. We're going to do partial payments for the next several months. And then when, we come out of this in 3 or 6 months or whatever it is, and we start rolling again, you're going to have to tack on portions of your missed rent, and your rent's going to go up, and you're going to be obligated to pay that. Again, you're seeking an amendment here. You're seeking to have them execute it, and to some degree looking at a solution rather than going right to, okay, you're not paying your rent, I'm getting you out of here, and the contract's going to break down, which would be a worse outcome, I think. So maybe approaching it from, what can you pay right now? And if I accept that as partial payment, are you going to be willing to up your payments at a later time? How do we need to stretch this out to make it make sense so that you can get caught back up, to maintain that relationship, but also to maintain that recurring revenue for yourself?
Yeah, so I think there's definitely a difference between your legal obligations and what you can legally do versus what you should do as
Right.
a business owner who is also just a human in this world right now, right? So technically, her
Exactly.
contract
Exactly
says
right.
no refunds. She is able to uphold that, right? That's what her contract says, and she could uphold that if she wanted to.
Yep.
You could
exactly.
choose to.
Yeah.
Okay, I think that is our last question. So in the box, I'm going to put a 4-question post-event survey. We'd appreciate
Yes,
it.
theoretically, and I'm sorry, I think my connection might be a little bad.
No problem.
Yeah, so theoretically, I agree that, yes, that's in the agreement, and you could technically dig in your heels and say, nope, no refunds, sorry, go try to sue me in court. And the problem is that they may sue you in the court of public opinion, which may be worse for your business long-term than finding some common ground and saying, hey, you deposited $1,000, $2,000, whatever. I can't give you the full refund back because our agreement states that there are no refunds, but I'll give you a partial refund. So, if they deposited $1,000, maybe you offer to give them $500.
You broke up again. All right. Oh, you broke up again. Are you back? Tony?
Yeah, can you hear me?
Yep.
Okay, sorry about that. Yeah, so maybe you take a partial refund approach to try to keep the relationship together.
Right. Yep. I think that makes sense because you are also a business owner too. And I think it's okay, like Tony mentioned earlier, to have those open lines of communication when you're having these conversations. Yes, there are legal terms that you could follow, but you want to have an open conversation and be understanding of their needs while also explaining that you have to pay your bills too. So I think it has to be a two-way street in that regard.
Exactly. Yeah, I agree with that.
Okay, so I think that we are at an hour, so that's a good time to wrap up. I posted a 4-question post-event survey. We're required by our funders, the SBA, to complete surveys for every webinar. We also appreciate the feedback. So please fill that out, and I'll also send it in a follow-up email that you can expect shortly. Thank you again, Tony. We really appreciate you delivering this presentation. Very, very timely topic. So thank you all for joining us today. This was recorded, and we will send this out in that follow-up email as well, in case you were wondering. Thank you again. Stay tuned to other upcoming webinars that may be useful to you as a small business owner. Thanks, everybody.